Good afternoon, everybody. Can you hear me okay back there? All right, good. How's everybody doing today? Food's good? Thumbs up? All right, great. Great to hear. My name is Eric Olson. I manage the insurance agency at Client First. It's my privilege to welcome you all today on behalf of Client First. And today's educational topic is on estate planning, so we're excited to get into that. Estate planning is one of the most crucial elements of a good financial plan. It's also one of the most overlooked components, and as many of you know, at Client First, our true holistic approach includes addressing this puzzle piece, and we're very excited to get into the topic that Rob's going to present today, 13 estate planning myths. We have a little trivia for today around the estate planning. So as I mentioned, it's a crucial element, often overlooked. So the question for today is, what is the biggest reason why 67% of Americans don't have an estate plan in place? So option A, I just haven't gotten around to it. B, I don't have enough assets to pass on to my loved ones. Or C, the estate planning process is too costly, they don't know where to start to get a will. So how many do we have? Who says A? Okay. All the above. All right. B and C. Okay. We'll call it lot for C. It's actually A. About 40% just haven't gotten around to it. So that's perfect because that's what Rob's here to help us with today. So a little bit about Rob. Rob's a native of Hubertus. He currently lives in Washington County, graduated from University School in Milwaukee, received his BA in Economics and Honors from Swarthmore College. Go Phoenix. He was also a member of the football and track teams there, and finally he received his law degree from Penn State University. Rob's focus over the last 16 years has been on estate planning and elder law. He frequently speaks on those topics and teaches several classes on estate planning at Moraine Park. He has significant experience in helping individuals and families who want to avoid probate, and he offers free initial meetings with clients to discuss various estate planning options, review meetings or review documents that clients have and determine whether and to what extent they may be updated. So other interesting facts about Rob, he's got 2 sons, he coaches football and hockey. And with that, I'll hand it over to Rob.
Thank you, Eric. Can everyone hear me in the back? Wireless microphone for the win. Excellent. Okay. Thank you for the introduction, Eric. So, again, estate planning myths. One of the reasons I like this particular presentation is because what I've found in my experience is there are a lot of myths when it comes to estate planning. And these myths usually come from relatives, friends, people we know in the community who are well-intentioned. These are people who want to give good advice, but unfortunately, 99% of the time, they're not lawyers. And the advice, though well-intentioned, may not be legally correct. So what I've done here is I've identified 13 of the most common errors that I hear repeatedly from clients or prospective clients or attendees of seminars or presentations that I do. I want to state what the myth is, and I want to explain what the truth behind the myth is. The first one ties in very nicely with Eric's trivia point, which I was not aware of prior to the meeting here today. The myth that I do not have enough assets to need estate planning. Very common myth. That's why I started out with it as the first one. Okay? So again, when it comes to an estate plan is a very broad term, and it's a term that evolves over time. In other words, the risks that we face and that need to be addressed by an estate plan once we turn 18 are very different than the risks that we need to address through an estate plan if we're approaching retirement. So whenever I give a public speech, I'd say 90% of the time when I do that, I make one statement. And again, with a crowd this size, it's hard for me to kind of see in the back, but I guarantee you that when I say what I'm about to say here right now, someone's going to roll their eyes. It's inevitable. I can give this warning and your eyes will still roll. Every single person over the age of 18 needs to have an estate plan. Every single person over the age of 18, okay? I'm going to explain that statement thoroughly to you, okay? You need those basic powers of attorney. Let's start with that. What is a power of attorney? Well, there are 2 types of powers of attorney. There's a healthcare power of attorney and a financial power of attorney. I always start with a healthcare power of attorney because I find that one to be a little more intuitive and arguably more important, okay? And I'm going to give some real life examples to make this a little clearer to understand. As Eric mentioned, I have two sons, 13 and 10. Right now, they are minors, okay? They both play a lot of sports. If they're involved in sports, or even if they're not involved in sports, even if they're driving in a car and we get in a car accident and they lose capacity, my wife and I, as their parents, have the ability to make medical decisions on their behalf, right? We can know what their treatment is. We can know what the doctors recommend. The moment they turn 18, we lose that right, okay? And that shocks a lot of people, okay? And there may not be many people in this room who have children under the age of 18, but there are many more people in this room who have grandchildren under the age of 18. Right at the age of 18 or a little bit higher. I apologize, okay? A lot of people in this room have adult children, but there might be some people in this room who have children of their own who are, let's say, between the ages of 18 and 25. They need to be aware of this because most 18-year-olds are still in high school. Most 18-year-olds still live at home. And we as parents lose that ability not only to make medical decisions, but also to even receive basic information regarding our child's condition if they end up in the hospital. Okay? So that is a type of estate plan that everyone over the age of 18 needs. Okay? The second point, now I'm going to focus on the group with people who have children under the age of 18, like my wife and I. Okay? And again, full disclosure, I'm a first-generation lawyer. Okay? If I didn't do what I did for a living as an average 41-year-old, to Eric's point from the beginning, I probably would not have an estate plan. Okay? But that's an alternate reality. The reality I live in is I do what I do for a living. Okay? But here's what I can tell you. When it comes to guardianship of minor children, that might be the biggest misconception that I hear. Because as I coach and as I spend time with the parents of my children's friends, we of course talk about what we do for a living. And inevitably when I mention that I'm an estate planning attorney, a very common response, again, based on myths about estate planning, is, I'm not going to need your services for a very long time. I kind of chuckle under my breath when I hear that because I know you have a son who plays sports with my son. I know you have children under the age of 18. An estate plan is the only, and I will repeat, the only way to determine guardianship of minor children. Okay? So again, going back to the example I mentioned before, maybe some of you in this room, maybe many of you in this room do not have minor children. But again, you very likely have children who have children of their own who are under the age of 18. They need to be aware of this. They need to know that if something happens to them, courts are going to determine custody of minor children. Nothing else works. Written letters, notarized letters, verbal understandings between parents or godparents or siblings, none of those are legally enforceable. Without an estate plan, courts are going to make that determination. Okay? Which ties into the third point a little bit. If you do not have an estate plan, the state of Wisconsin creates one for you. Okay? Now, another sub-myth to this myth is that if the state of Wisconsin creates the estate plan for you, the state gets everything. Okay? Fortunately, that's not true. Okay? See, most of the myths I'm going to talk about today are basically bad news. In other words, if we relied upon the myth, we'd be in a better position than if we actually learned the reality. Okay? This one's the opposite. This is one of the rare ones where it's actually in our interest to know the truth as opposed to being in a situation where we're relying upon the myth. So the state of Wisconsin creates the estate plan for you, but they don't get everything. Okay? So again, the main overarching point, there are many types of estate plans for everybody, regardless of age, regardless of income, regardless of marital status, regardless of whether you have children, and regardless of asset levels. And they do need to be adjusted over time. So to kind of walk through a little bit of the evolution of an estate plan, as I mentioned, first part of it is once you reach the age of 18, have those powers of attorney in place. Next event, marriage, right? There's Wisconsin marital property laws that come into play. If you get married, first of all, you probably want to update your powers of attorney because as opposed to your parents, you probably want your new spouse to be the one making medical or financial decisions if you become incapacitated. Which kind of ties into another point, okay? Married couples, okay? And I'm going to walk through this hypothetical, okay? I drive from here to my next appointment. I'm on Highway 33. Okay? I'm sure many of you have been on Highway 33 before, okay? Somebody crosses a double yellow, hits me head on. I'm taken to the hospital. I'm in a coma, okay? If I do not have powers of attorney, my wife not only cannot make medical decisions for me while I'm in the coma, she can't even find out anything about my condition while I'm in the hospital. Because sharing that information without my consent, which of course I can't give if I'm in a coma, violates my HIPAA rights. So I'd be willing to bet people who have not heard me speak on this would have assumed, well, it's the spouse. Of course the spouse can receive information. Of course the spouse can get privy to that information from the medical providers. Not so without a power of attorney. Okay? So that is one of the biggest myths when it comes to estate planning. The idea that I need to have enough money to create an estate plan. If you're over 18, you need an estate plan, period. Myth number 2, married people do not need POAs. Okay? We just talked about this a little bit. I talked about it from the healthcare perspective. Now I'm going to talk about it from a financial perspective. Okay? Again, Wisconsin is a marital property state. Basically what that means, and I'm oversimplifying here, but basically what that means is that when one spouse passes away, everything passes to the surviving spouse basically by operation of law. Again, that's an oversimplification, but that's the general takeaway from that. Okay? The problem is people incorrectly assume that the next logical step with that is that they do not need to have powers of attorney because they own everything jointly. Okay? And there's 2 problems with that approach. Problem number 1 is this. Okay? Most of my married clients own a lot of assets jointly. For instance, most married couples own real estate in both spouses' names. Very common. Most of my clients who are married have joint checking, joint savings accounts, joint bank accounts, things like that. But there are quite a few assets that can't be owned jointly because there's just no mechanism to own them jointly. I'm going to list a couple of them here. IRAs, whether traditional or Roth, 401ks, 403bs, and life insurance. If we own any of those assets, they can't be owned jointly, period. Now, the very common retort I get is, but my spouse is the beneficiary. And what I say is, that's great. What does a beneficiary mean? A beneficiary gets access to the money when the owner dies. If the owner is merely incapacitated, that person's status as a beneficiary is absolutely useless. Okay? So that's why we need powers of attorney, so that the healthy spouse can access that money and make financial decisions over that money. The second reason is this. Married couples specifically, okay? I've been practicing law for 16 years and nobody's ever been able to prove me wrong on this, okay? If you take any given married couple, there are only 3 possibilities as far as order of death and dying. There's only 3. Spouse 1 dies first, spouse 2 dies first, or they both pass away together. No 4th option, okay? What I can tell you is this, okay? Again, when one spouse passes away, call it spouse 1, spouse 2, of course, can't rely upon spouse 1 anymore. We need to have backup agents. Maybe those are adult children. Maybe it's siblings, family, friends, parents, whomever these people are. We need to have them nominated so that they can make decisions. So again, the mere fact that you're married does not preclude the need to be able to have powers of attorney in place. It's necessary, okay? Again, we talked about guardianship, okay? I talked about it kind of tangentially. I'm going to bring it more into focus here with this slide, okay? In the event that we do not have an estate plan, parents pass away, we have the children who need to have a guardian appointed. That's what ends up happening there, okay? But this type of guardianship is different. I just want to make sure we're on the same page. So what happens? And again, I'll make this easy to understand, okay? It's easy to understand in the sense of, let's say you go to any ICU at any hospital, okay? You're going to get a wide variety of ages, things like that, okay? Of course, it's not true that 100% of the people in that situation have powers of attorney. So what happens? What happens if we lose capacity and we don't have a power of attorney? The answer is we need a court-ordered guardianship. So that's different. I wanted to make sure we understood the term. Guardianship as it relates to children is different than guardianship as it relates to being able to oversee the financial and healthcare decisions of a person who's incapacitated. So the average cost of guardianship is about $4,000. It takes about 2 to 3 months to go into place. So that's what we want to avoid. And again, the only way we can avoid that is if we have powers of attorney in place. Okay? And again, we talked about that last point. Spouses don't have the ability to make those decisions. Okay? Myth 3. If I have a will, I do not need further estate planning. Okay? This is probably, again, I say this a lot during the course of the presentation, one of the very common myths that I hear. Okay? I think the easiest way for me to explain this is to kind of walk through what a will is and what it does. Okay? Because in my experience, by far, the word that's most commonly associated with estate planning is will. I need to have a will. Even Eric's trivia question contemplated a will. The word trust was never mentioned in the trivia question. Okay? Only the word will was. Okay? So let's start with that. Okay? What is a will? A well-drafted will is always going to do 2 things. And when applicable, it's going to do a third. First thing a well-drafted will does is determine who your beneficiaries are, okay? Who or what, in the case of charities, are going to receive the proceeds of your estate after you pass away. Okay? Second thing the well-drafted will allows you to do is determine who's in charge of the estate. You've probably heard the term executor before. Okay? Personal representative, they're the same. It's like lawyer and attorney. They're exactly the same thing. They're interchangeable words. That person's job is to basically get the assets into the estate, pay out final expenses, and distribute the proceeds. Okay? The third thing the well-drafted will do sometimes, as I mentioned before, determine guardianship of minor children. Obviously, if you don't have minor children, that point falls off. Okay? And that's what a will does. Here's the limitation with will-based planning. The limitation is this. A well-drafted will, even a perfectly drafted will, is not guaranteed to avoid probate. Okay? That is one of the biggest misconceptions that I run into in my practice. Again, what does that come from? It comes from the understanding that in some cases, wills will avoid probate. Well, my mom or dad's estate occurred. They passed away. They had a will. They avoided probate. That's all I need. I don't need anything beyond a will because it worked for mom and dad. Well, maybe mom and dad's situations were different. Laws change. Probate thresholds change. Real estate issues change. There's any number of variables that may cause one estate to go through probate and another estate to go through probate. But again, let's back up a half a step. What is probate? Probate's the process where a court oversees the administration of an estate. When an estate goes to probate, there's a series of hearings, a series of filings, a series of deadlines, a series of events that occur before assets go from the name of the deceased to the name of the beneficiaries. Okay? As an estate planning attorney, my goal is to encourage my clients to create plans that are guaranteed to avoid probate. Okay? And this slide gets into some of the reasons we want to avoid probate. First of all, it's expensive. Average cost of probate in a state is between $5,000 and $10,000. Secondly, it's time consuming. Average length of probate is about 18 months. Third is it's all public record, okay? And it's not only the wills that become public record, okay? It's the assets that go into it. And I'll give you an example, okay, just to make this clean, okay? I know there's a lot of friendly faces in the audience, people I know, people I've worked with before, okay? But there's also people I've never met before. The people I've never met before, I will tell you right now the distribution of my estate plan, even though we've never met before. I am happy to share that, okay? Everything goes to my wife if she survives me. If she doesn't, split evenly between my two sons once they reach the age of 30. I have no problem sharing that with people I've never met. I have no problem with that being public record. Unfortunately, when you have just a will-based plan and it goes to probate, that's not all that's public record. The amount and the character of the assets that I have that pass through probate also become public record. And that I don't feel comfortable sharing with you guys. That I don't feel comfortable having become public record. And that does necessarily become public record if we have a will that goes through probate. Okay? So again, just to make sure we're clear, the three negatives of probate: cost, $5,000 to $10,000, timing about 18 months, and the fact that it's public record. Okay? How do we avoid probate? Okay? And we're going to start talking about these a little bit here, okay? But before we go into that, let's talk a little bit about wills, okay? Again, we've talked about why we want to avoid probate, some other limitations. Wills do nothing to avoid nursing home estate recovery. Okay, that's another misconception people have, that they'll somehow avoid nursing home estate recovery. Wills don't do that. Wills offer no protection from that. Okay, now trust may not either, candidly, but I want to make sure we dispel ourselves of that myth right now. Wills also limit your ability to customize your distribution. Okay, and again, I'm not going to ask for a show of hands, but broadly speaking, every single person in this room falls into one of three groups. One, you have neither a will nor a trust. Two, you have a will-based estate plan. Or three, you have a trust-based estate plan. Every single one of you in this room falls into one of those three groups, okay? And here's what I will tell you if you are in group two, and you just have a will and you don't have a trust, okay? And what I'm about to say may sound counterintuitive on the surface, but I promise you it is 100% legally correct. A well-drafted will should have as few assets as possible pass through it, okay? If you are resigned to group two, it should have as few assets as possible pass through it. Why? Because we're relying upon beneficiary designations on our assets to bypass the will. For example, if you have an IRA, okay, we list our beneficiaries on the IRA. Spouse is the primary, kids is second, however we do it, okay? That asset does not pass through the will. It passes through beneficiary designation. The limitation with wills because of that is sometimes we can't customize the distribution, okay? Let me give you an example of that, okay? if we're in a situation where, and I always use this example of my grandmother's situation, okay, and those of you who heard me speak before, I apologize because you've heard me talk about this, okay? Again, I try to incorporate as many real-life examples as possible. My grandmother's okay with me sharing this, okay, just to make sure, because she gets the attorney-client privilege too, not just because she's my grandmother, right? That's included there. My grandmother has 5 sons, okay, 5 boys. When I did her estate plan, which of course I did as a first-generation lawyer, I did her estate plan, I asked her, how do you want the assets divided? She said 1/5 to each son. Makes perfect sense. That's what 99% of people in her situation would do. I then asked the question to my grandma. I said, Grandma, what happens if one of your sons dies before you? My grandmother's response was, well, that's not going to happen. Again, love my grandmother to death. Grandma, I know you don't want to think about it. I get it, right? And I also understand that I deal with death and dying for a living. I understand maybe I'm more desensitized to it than the average person. But I said, Grandma, on a professional standpoint, that could happen. What do you want to do if one of your children passes away before you? And broadly speaking, anyone in my grandma's situation or in any situation has 2 options. Option 1 would be the deceased child's share would go to his children. Okay? So her grandchildren from the deceased son. That's an option. Second option would be that it would just get divided 4 ways, right? So if there's 5 sons, 4 end up surviving her, it gets divided 4 ways. Okay? There's nothing right or wrong with either option. It's based on personal preference. What I can tell you is about 95% of my clients choose option 1. They want the son's share, if he predeceases, to go to his children. Okay? Can't do that if we have a will for assets that are passing through beneficiary designation on things like bank accounts or any of those types of assets. So it limits you in terms of how you can do it. Wills also do not provide spendthrift protection. Let me explain what I mean by that. Okay? When I draft a trust, we put in language that says money can be held by the trustee if there is some sort of situation for the trustee to want to hold the money. Okay? I'll give an example. If we have a will and we're relying upon beneficiary designations, the money simply passes the beneficiary once the owner passes away. Okay? My question is this. We draft the wills or we draft the trust in time 1. How do we know in time 2 that a beneficiary is not going through a divorce? How do we know that the beneficiary is not going through a bankruptcy? How do we know that they're not having some sort of addiction issue, drugs, alcohol, gambling, whatever the case is? When we have wills, we don't get that protection. The money just goes. The moment somebody passes away, it's gone. Okay? A trust, on the other hand, the trustee can hold on to that money until that situation is reconciled. So again, for 99% of my clients, the trust-based plan is the way to go. Now, in certain circumstances, a will-based plan is sufficient, but it's all based on facts and circumstances. But again, the main thing we need to know there is if we're in a situation where we have more than $50,000 worth of probate assets, we should consider trust-based planning because that's the only guaranteed way to avoid probate. Okay? One other point I want to make on wills is that wills are significantly easier to contest. Okay, everyone's heard about the will contest. Hollywood does a great job of talking about the will contest, right? And I can tell you this, by the way, I always mention this. So whenever people see a will reading on TV or in a movie, that's all Hollywood. I've been practicing law 16 years. I have 4,500 estate planning clients. I have never once read a will in my life. Okay? It doesn't happen. That is all Hollywood. Okay? But what I will say is this. It is easier to contest a will. Why? Because it's public record. Anybody can go to the courthouse and get anybody's will. Okay? So another advantage of creating a trust is to make sure that it's more difficult to contest. Because I can tell you this. When I create trusts for my clients, and I don't care how well or how poorly their beneficiaries get along, I always put in what I call a no contest provision, which basically says if anybody contests this trust, even if they're successful, they get $1 and nothing more. Okay? That is a way, for, again, I'm not pointing out existing clients, but existing clients, look, it's in there, I promise. Okay? So that's something to think about, right? It makes it more difficult to contest. Not that we would ever need to be in that situation, but hopefully if we ever are, we have that protection in place. Myth number 4, I plan to leave everything to my spouse and then to my children, so I do not need an estate plan. Okay? Again, I apologize. When I do these kind of presentations, I kind of do them off the top of my head, so sometimes I repeat things on future slides just because that's where the train of thought takes me to. So again, a lot of this we already talked about, but I want to focus on the last point here. Probate is required whenever the probate assets exceed $50,000 unless the decedent has a trust. Okay? So again, if we're in that situation where we're over $50,000, and the biggest culprit there is equity in a home. Most of my clients own homes. Most of my clients have more than $50,000 worth of equity in the home. So those assets will become probate assets. So That's really the touchstone. So basically the only time I don't recommend trust-based planning for my clients is if they don't own real estate, okay? But again, the idea of I plan to leave everything to my spouse and then to my children really doesn't work, because of course that's your intent. That's what 99% of people who have children's intent is if they're married. The problem is that doesn't help with probate avoidance. That's the main thing I want to take away from this. Final one, incapacity happens, right? Estate plans don't inherently deal with incapacity. If you have a will, you have a trust, that deals with distribution of assets. It has zero to do with those power of attorney decisions we talked about before. So where you plan to leave your assets is not at all related to making sure you have documents in place to allow someone to make medical or financial decisions for you if you become incapacitated. Myth number 5, estate planning is expensive, okay? Again, expense is relative. That's one thing I've learned in my practice. I have some clients who, when they hear my rates, like, I can't believe it costs that little, can't believe it costs that much. It's all relative. It's all based on value, okay? But again, what I can tell you are these 2 points. These are the 2 main points. One, there's a wide variety of options, okay? I am not going to recommend a trust-based estate plan for an 18-year-old going off to college or going in the military. It doesn't make sense. They need to have powers of attorney so mom and dad can make medical and financial decisions, but they don't need full-blown trust, okay? But the second point is the one I want to really drive home, that the cost of not creating an estate plan is often significantly higher than the cost to create one, okay? This is what I call the dentist example. Okay, do we have any dentists in here, by the way? And again, I'm not going to make fun of dentists. I love dentists, okay? But here's what I'm going to say as an example, right? What does my dentist tell me all the time, right? The more you brush, the more you floss, the more you do that kind of stuff, saves you money and time down the road, right? Paying for 2 cleanings a year are a lot cheaper than paying for no cleanings and having to have 4 root canals done, right? It's a similar type of concept when it comes to estate planning. Yes, it's going to cost money to create the plans, but the money you spend to create the plans is going to save significant time, significant costs, significant aggravation down the road for your children or other loved ones after you pass away. Myth number 6. I'm going to kind of take this one in a different direction here, okay? And I'm going to kind of just walk through all of these before I start. I get this question all the time, this idea of nursing homes, okay? And those of you who have attended my other lunch and learns, I have done several lunch and learns on the issue of nursing home estate recovery and how that works. So that in and of itself is kind of outside the scope of what I'm dealing with today, but I will bring it in through this myth and the next myth, okay? The idea that we have this 5-year look back period. Let me briefly define what that is, okay? And I'm just going to kind of start at the end, okay? Right or wrong, this is not a shoot the messenger moment, okay? I'm just telling you what the law is, okay? The state of Wisconsin takes the position when it comes to nursing home estate recovery that if people have their own assets, they should use those first to pay for their own nursing home care. They should not be able to protect assets for the benefit of their children and then go to the government and ask for money to pay for nursing home care. You can sit here and say, whether that's right or wrong, that's the way the law is and that's the way the regulations are based upon, okay? But they do have what's called a 5-year look-back period, okay? Meaning that if you give away or transfer assets 5 years prior to when you need the government to help you pay for nursing home care, that's exempt, okay? And I'm just giving a high-level explanation, very brief explanation of it. Here's the problem. Humans are procrastinators, okay? That is one thing I've learned in my personal life, and it's certainly been reinforced many, many, many times in my professional life, okay? The most common call I get when it relates to nursing home issues is, Mom and Dad is on the figurative doorstep of the nursing home. What, if anything, can we do? And then people start to go online, and they start to play amateur attorney. And they find out about this 5-year period, and they come back to me with a sense of dejection saying, nothing I can do within the 5-year period. That's not true. There are things we can do to help preserve assets during that period, okay? And I've listed a couple examples here. Funeral trusts, burial reserves, automobiles, home improvements, vacations, okay? These are ways to preserve assets, particularly with funeral trusts, okay? We have the ability to create funeral trusts and fund it up to $15,000 per person for an expense that we know is going to happen, okay? Again, I can't tell you much certainty, but I can tell you 2 things with 100% certainty. 1, hate to break it, we're all going to die at some point, okay? It is inevitable. Until they come up with an immortality pill, we are all going to pass away at some point in time. Secondly, regardless of what our preferences are, we are all going to have expenses associated with our passing, okay? Now, those can vary based on personal preference, religious affiliation, whatever the case is, but nobody goes for free, okay? So being able to set up funeral trusts or burial reserves allow us to take assets that would otherwise be available to pay for nursing home care and set them aside for those expenses. Automobiles. One vehicle is exempt. A lot of my clients drive older vehicles. Take some of that cash that would otherwise have to be spent down and use it to buy one vehicle. Now, don't go out and buy a Maserati, buy something practical, right? But at the same time, you have the ability to protect assets through one vehicle. Home improvements. This is another big one, okay? I've yet to meet a client in my practice who says, you know what, I want to go to a nursing home. Never found that client, okay? Everybody wants to stay in their home for as long as possible, and I get it, okay? But as we get older, sometimes we need to improve the home to make it more accessible. We widen showers, we put in ramps. All of those are acceptable even within the 5-year period. Taking vacations, okay? You can do that too. I'm going to give one overarching explanation when it comes to what the government does and does not allow you to do, okay? The government doesn't care what you spend your money on. You can spend it on any of these things and any other thing. You just can't give it away. That's really what it comes down to. The government does not want you to give it to your kids or give it to a charity or give it to someone else. As long as you spend it on you and your spouse, you're okay. If you give it away, that's what causes a problem, okay? Which kind of ties into myth 7. I should give my home to my children while I am alive, okay? I'm going to walk through this one because this one, again, I hear this, I'd say at least once a week, okay? First of all, it will not avoid the 5-year look-back period. If you give away your house tomorrow, we start that 5-year look-back period that day, okay? If there's multiple children and one predeceases, what happens then? I run into that all the time because people won't consult me first. They'll say, here, I already did this. Now I have a mess. What do I do? Okay? And I'm limited in that regard, right? Circumstances change, and once it's given away, it cannot be changed. I unfortunately run into this all the time. This is one of the most difficult parts of it. I mean, to be honest, the most difficult part is when clients pass away. That is by far the most difficult part of my job. Second most difficult part is when I have a client whose loved one starts deteriorating from Alzheimer's or dementia. It's tragic, okay? But once we get past the death and dying issues, the hardest part of my job is when people change their minds about conveying the home. And it happens all the time. The most common example is this. People receive that myth, that incorrect or incomplete information to transfer the home to the kids. They transfer the home to the kids. 15, 20 years later, they forgot they did it or they don't understand the consequences of it. They don't want to have the 10-acre house anymore. They want to buy a condo in downtown West Bend or downtown Hartford or wherever the case is. And they call me because they say, my bank wouldn't allow me to do it. My realtor said I can't do it. Why? And I look at the document and I say to them, you don't own the home. It's not your home. It's your kid's home. You got to get approval from them to do it. And there's whole other host of issues that come into play. Ungrateful children, okay? Maybe it's just because of what I do for a living. I'll admit I could be biased here, but it seems like every single year I hear a story about someone doing this and the kids kicking the parents out of the home. Now, that's when I hear that. Not my child. Someone's definitely thinking that right now. Not my child. My child would never do that, right? But some children do. And that's why we have this, okay? Second issue is creditors, okay? Let's say the home was transferred. You transferred it to your 2 children. And that's why I asked, do the children drive? What if they get in a car accident and they have insufficient insurance to pay for a claim? Guess what gets liquidated to satisfy that judgment? Your own home that you conveyed to your children. You are now homeless. That's a problem. Divorce. Half the marriages in this country end in divorce. What happens if you convey your home to your children and they get divorced? Well, that home is considered a marital asset. Okay? Big problem. You may have to sell your house to buy your in-law, or your ex-in-law, that is, out of the interest that you have with your child. Nobody wants to do that. Last issue is capital gains. Okay? This is the second bit of good news I'm going to give you. It's been all bad news today, but I'm going to give you a second bit of good news. Okay? And again, the folks at Client First can walk you through the specifics of it. I'm just going to give the general explanation. Okay? There is an exemption under the federal tax code for when you sell your primary residence. Okay? In other words, when you sell your primary home, the gain that you make on the sale of the home based on what you purchased it for versus what you sell it for, if it's less than $500,000 for a married couple, the gain, not the sale price, that is tax-free. Okay, that's good news. Okay? The bad news is that only applies if it's your primary residence. So if you give the home to the kids, unless your kids live with you, that's not going to work. They're going to pay capital gains on that. And I have a lot of clients who bought their houses in their 70s or in the 80s, and they're worth 300% more than they were at the time they purchased them. They're going to get hit with that capital gain. So transferring your home to your children is usually never a good idea. 99.9% of the time, it's not a good idea. I ran across the 0.1% of the time it was. It's my unicorn, okay? And I'll tell this story, okay? I had a client who sat down with me, son, father. Mother died a few years ago. Father met with me, said, I want to transfer the home with my son. Okay, father was probably in his mid-80s, son was probably in his early 60s, okay? And here I am getting prepared to give him the same spiel, going through all of this, and I'm walking through it, okay? And I explain to them the problems, okay? So the first thing that they tell me is that the son lives at home. The son has never left the home. So he's been residing in the home all 60 plus years of his life. Okay, that's rare. Not completely unusual, pretty rare, okay? Son is not married. Again, not rare either. But here's the wrinkle with that. Son tells me he's never even been on a date. So here's my thought process, right? What are the odds that this 65-year-old man is going to find true love after having never been on a date in his life, okay? It gets more incredible. And this is a law school exam question at this point, right? He doesn't even drive a vehicle. Never got a driver's license. And this is not someone who has developmental disabilities, though. This is a normal functioning person who just chose this lifestyle. So I said, you know what? These risks are pretty low. Transfer the home to your son. Go for it, right? But again, I could practice another 300 years and never come across that again, okay? So again, general rule, don't give the home to the kids while you're alive. Myth number 8, trusts are only for wealthy people. Okay, again, I hear this one quite a bit as well. I'll give a very simple explanation. I'm running a little short-ish on time, okay? Trusts have nothing to do with wealth under Wisconsin law if you have more than $50,000 worth of probate assets, okay? Now, if you have $51,000 worth of probate assets, you may or may not consider yourself wealthy. Wealth is relative, okay? But I will tell you that every single person who has more than $50,000 worth of probate assets should have a trust to avoid probate, okay? It's that simple. It's for the reasons we discussed at the very beginning of this presentation. Probate is bad. We want to avoid it. The only guaranteed way to avoid it is to create a trust as opposed to having your will-based plan in place, okay? Trusts can provide creditor protection for beneficiaries. We talked about that earlier, but I'm going to refocus on that point because there's value there, okay? When we have a will-based plan, as I mentioned, we're relying on beneficiary designations. Typically, those take the form of what's called a POD or a TOD. POD is payable on death, TOD is transfer on death. Don't get caught up in the difference between the two. It's basically on death. It's an agreement that you have with the holder of the asset to say, hey, when I die or when we die, pay this money to my beneficiaries. Right? The problem is the holder of the asset can't take into account the divorce that the child is going through, the bankruptcy that is pending, or the addiction issue that your child has. Trusts can. So it's yet another benefit to creating a trust-based plan. Okay? Special needs. It's another issue I want to talk about. 1 in 5 families have beneficiaries with special need issues, okay? Having a trust in place allows you to leave money to your children who have special needs without disqualifying them from governmental benefits, okay? If we have a will, we just list money to that beneficiary, that person who's receiving governmental benefits will lose those benefits dollar for dollar. What is the net effect of that? You're basically disinheriting them. That's pretty much what it comes down to. The inheritance they receive substitutes for their governmental benefits. The net effect is you're disinheriting that person, and Uncle Sam's getting all of it. Okay? So again, if we have children or grandchildren who are receiving those governmental benefits, creating a trust with a special or supplemental needs trust built in is a way to allow us to be able to leave money for the benefit of that child who's receiving those benefits. Okay? But without direct access that will disqualify them from the benefits. What's good for the goose is not good for the gander. Okay? I can tell you that, again, I've used this same story. As estate planning attorneys, as the father of 2 kids, they say, Dad, why do you tell the same 10 stories all the time? Which is kind of par for the course, right? But I've told this story before. I had a situation where I was a young attorney, 6 months out of law school. I was sitting in a probate office, and it was pretty clear it was the mother with the adult son. Father had just passed away. They're talking with each other. They're in line. Mother says to the son, do you think now with Dad's passing, this is the time that I should finally get my estate planning documents squared away? Mm-hmm. The son's response was, Mom, don't worry about it. This is easy. We didn't have to do much. We went to court. We did this. Signed a couple pieces of paper. Don't worry about it. You don't need an estate plan. Now, as of now, I'm 16 years out of law school as opposed to 6 months out of law school. When I was 6 months out of law school, I didn't have the courage to talk to them and say, hey, that's not exactly correct. Now I would have, okay? Because the problem is this. Under Wisconsin law, in general, when one spouse passes away, it's very smooth. And 99% of the time does not implicate probate, okay? Because everything just passes to the surviving spouse by virtue of marital property laws. Not true when the second spouse passes away. When the second spouse passes away, again, if we have more than $50,000 worth of probate assets, the estate goes to probate. So again, those laws do change. Just because it was easy for spouse one does not necessarily mean it'll be easy for spouse two. And again, that's a lot of incorrect information that people come in with. They'll say, my limited exposure to estate planning was my mom passed away. My dad's still alive, my mom passed away. They just had wills in place. It was nothing. I don't need a trust. It was very easy when mom passed away and dad's still alive. What I want to say to them is well, with all due respect, what's going to happen when dad passes away? Okay, it's not going to be as easy because marital property laws no longer apply. Not all beneficiaries are created equal. Okay, we talked about this a little bit, but I just want to make sure that we're on the same page here. Okay, and I'm going to go back to my example with my grandma with this one. Okay, I mentioned before about how my grandma had the plan where she had all 5 children listed. Okay, and the difference between a deceased child's share going to his children or being split among the survivors. Okay, as you can imagine, there's a big difference there. Okay, the problem is that a typical bank asset, checking, savings, CDs, money market accounts, they don't let you list what they call a per stirpes beneficiary. Okay? If you look at the slide here, second last point, per stirpes is Latin for along the bloodline. So that's the idea that, again, if a son predeceases, his share goes to his children. Can't do that unless we have a trust on bank assets. So that's yet another reason to create a trust. And by the way, for what it's worth, just to kind of finalize the story, my grandmother is 87 years old. 2 of her sons have already passed away. Okay, so my Uncle Dave, my Uncle Chris both passed away. So there's 3 left. Okay, so this can and does happen, by the way. Okay, so again, the idea there is making sure that we have beneficiaries in place. And one other thing that I'll tie into this point is this, and it's kind of like a sub-myth, if you will. Okay, people will incorrectly believe that if they create their will or they take my advice and create a trust, then that document governs, and it's going to supersede all beneficiary designations. That is not true. It's the opposite. Beneficiary designations are always going to supersede what is in a trust or will. I'll give you a practical example of this, okay? Now, parts of the story are true and parts are not true. Okay, I always want to disclose what parts are true and what parts are not true, okay? When I got my first job out of law school, okay, I was married right after I graduated law school. Okay. The week after I graduated law school, we got married. Okay. So my first job was the first, I'll call real job where I had benefits. I had a lot of jobs growing up, right? But a real job with benefits. Okay. So one of those things required me to create a 401k program, profit sharing. Great. Who do I list as my beneficiary? Well, of course, I list my wife as a beneficiary. So she's the first beneficiary. Okay. This is where it diverges. Obviously, I'm here. I started my own practice. But let's say I stayed with that exact same firm throughout my entire 16 years of my practice. Okay. And let's say a couple life changes that didn't actually occur did occur under my hypothetical, okay? And issue number 1 is I get divorced, okay? So let's say in 2015, I get divorced, okay? And I get remarried. That happens. Again, half the marriages in this country end in divorce. I have wife 2, I'll call her, okay? Wife 2 and I, we get older, we get on the ball, we decide to create an estate plan, okay? My wife 2, I should say, wife 2 and I create the estate plan. I leave everything to wife 2. Except, I never changed the beneficiary designation on my original 401k. And it lists wife 1 as a beneficiary. So I have my will, I have my trust, everything going to wife 2. I die. Who gets the 401k? Wife 1. You could see why that would be a problem, right? Particularly with wife 2 would be my guess. I don't know. But I guess that's my point, right? I just use that example to underscore the importance of having beneficiaries and not relying simply upon what the estate planning documents say, okay? Out of sight, out of mind, okay? Again, it's what I call the set it and forget it mentality, okay? And one of the things that I took a lot of pride, and this is completely unrehearsed, by the way, because this occurred as I was walking in today. And I'm not going to use names, of course, but I had 3 different couples today before this meeting come up to me and ask me one question. Rob, you did my trust. Do I need to make any changes? And that made me smile. Okay, it did. Okay, here's why. Because one of the misconceptions I very commonly run into is when people create an estate plan, they set it and forget it. They just don't look at it anymore. They know it's a thing to check off the bucket list, right? Most people have that sense. But then they think it's just going to be fine. I did it. It's done. It's over. So I'm glad I was able to, because those 3 people didn't do it on their own, right? It's because I told them, hey, maybe we should look into this a little bit and remember to look at it every now and then. Great. Not a lot of attorneys do that. And I've had a lot of clients who will come to me 20, 30 years after they created their initial documents, and because client first gives them a reminder and says, hey, you can meet with the estate planning attorney we work with, otherwise they would never even review them. So that's my advice to you. Whether I drafted your estate plan or I didn't draft your estate plan, if you have one, look it over. Take a minute and ask yourself 2 questions. 1, the way the documents are currently drafted, are the people we want receiving the proceeds of the estate receiving the proceeds? What life events have occurred between the time you created the documents and now? I always talk about 3 Ds and a B: death, divorce, disability, and birth. Those are 4 big life events. And those may cause you to want to update your estate plan. And if those events occur and your estate plan isn't updated accordingly, it's not going to be accounted for. And that could end up being a big problem. Okay? I always talk about life happening. Those life events do occur. And again, as an estate planning attorney, I can tell you if there's law changes, right? That's on me. If there are law changes that impact my client's trust, it's my job as the estate planning attorney to let them know. Okay, but if there are these life events that occur, I have no way of knowing unless you tell me. Okay? So again, my advice is every couple of years, 3, 4 years, whatever the case is, just take a look at the documents and ask yourself those questions. Okay? In-laws and outlaws. Okay? This is what I can tell you. I can tell you in my experience, and again, I am privileged to have wonderful in-laws, okay, to a person. My mother-in-law, my father-in-law, my sister-in-law, really like them. I hit the in-law jackpot, okay? Not everyone is so lucky in that regard, okay? I can tell you that in my experience, when there are problems with the family, the overwhelming majority of the time they are caused by in-laws. So again, the idea is, and I just want to make sure we're on the same page here with this, there's a couple important points. The main one is this. I have children who are beneficiaries, okay? And here I'm going to use an example of my parents, okay? I used my grandmother before, now I'm going to use my parents. Again, have their permission too. I have a sister, okay? The way their estate plan is set up, 50% to me, 50% to my sister. Pretty straightforward, okay? Here's the problem. Let's say, and this is not the case, at least I don't think it's the case, that my parents really, really didn't like my wife. They despised my wife, okay? And if I didn't do their estate plan, we meet with the attorney. Okay? We're in the attorney's office, I'm in the office, and my parents raised the question of, what happens if Rob gets divorced? How do we make sure my wife, Erica, doesn't get access to the money? Okay? That's a common concern, okay? And what I'm going to do now is I'm going to explain legally what can be done, okay? Here's how the conversation would have to go. In order for those assets to be protected from being marital property, they cannot be commingled. That's a fancy legal word that I'll describe through the hypothetical, okay? I receive that information, I go home to my wife, okay? Rob, how'd the meeting with the attorney go? Pretty good. But my parents are concerned about our divorce. They don't really like you very much. They are concerned, and they do not want you to have access to the money. So here's what's going to happen. When my parents die, whatever inheritance I receive, I am going to keep in a separate account. Your name will not be on that account. And on the attorney's advice, any joint expense will not be paid out of that account because even if 1 penny is used for joint marital expenses, it all becomes marital property in the event that you divorce me. How does that sound? I'd argue not great, okay? But legally, that's all that can be done to protect those assets from a spouse. So again, I always tell my clients, there's legal advice and there's practical advice. And I just explained both in a matter of 30 seconds there. But again, that's where it becomes problems with in-laws, okay? Now, what I will also say is this, kind of the good side of the in-laws, right? I have a lot of clients who will say, I really like my in-laws. I like my sons and daughter-in-laws. I want them to receive my child's share if they predecease me, okay? But here's what I always caution them against, okay? If you're going to do that, make sure we have a provision that says, provided that person was married to my child at the time of his or her death, right? Because what if the divorce occurs right before you pass away? That can be a big problem, okay? And I had a situation with that yesterday, where that provision was not built in to have it be predicated upon them being married at the time of death. And I said, that's a practical problem, right? We talked about it before, 50% of marriages ending in divorce. We want to make sure we have that provision in place. But again, the importance of family meetings. Again, there is an attorney-client privilege. That is a sacred relationship, okay? The attorney-client privilege can be compromised if the client chooses to compromise it. The client, for example, can choose to allow me to communicate with the client first. It's a very important disclosure. We work together, make sure everything goes the way you want it to go. But also can be waived for the purpose of having family meetings to make sure that everybody's on the same page. I am a huge fan of family meetings. The more information we can get out to more people, the better. That said, sometimes people don't want to have those client meetings with families. I respect that, and it's ultimately their decision as to whether they want to have that information shared. The final myth is finding the right attorney. Okay? Now, admittedly, this is a bit self-serving, but I will say it anyway. Okay? Here's what we're looking at here. Because again, I know I work with a lot of you. I know I don't work with a lot of you either. Okay? There may be some of you who are very happy with your attorney. There might be people who've never considered meeting with an estate planning attorney. Okay? We talked about that attorney-client privilege. Here's what I can say in general when it comes to estate planning attorneys. Broadly speaking, there's two groups of estate planning attorneys. There are the estate planning attorneys like myself who do this exclusively, and there are the estate planning attorneys who do this as part of a general practice. Okay? I'm not saying that one's right or wrong, but I'll give you an example. If you're having a heart attack, do you see a cardiologist or a family doctor? Just leave it at that. I mean, that's probably the best way I can describe it. Okay? And that is not to cast shade on any general practitioner. That's just kind of a fact. Okay? I have some common questions that you may want to ask your estate planning attorney if you're in the process of meeting with or interviewing estate planning attorneys. But I'm running low on time here, so I'll probably pick two of these to focus on here. The first one being, what percentage of practice is devoted to estate planning? That kind of ties into the point that I mentioned. And then the other question is, do I charge for revisions? Okay, what I can tell you is this. For my existing clients, I do not charge for revisions. So if I do a set of estate planning documents for a client, and down the road they have those life changes that occur that may cause them to want to update the documents, I do not charge for revisions. Okay, I've heard that I may be the only attorney who does that. Okay, I don't know. All I can tell you is other attorneys who do charge for revisions, that can be a cause of consternation for a lot of my clients because they don't want to have to pay for the same estate plan twice. Okay, so again, thank you for the opportunity to present on some of these myths here. I do have a little bit of time for some questions. Otherwise, thank you again.
Okay, thank you, Rob, and hopefully everyone found that some useful information. I got a good one for you. Mrs. Smith, fifth grade teacher, posed this question in her class. She said, you got a millionaire, guy has $10 million, and when he passes, 1/5 goes to the wife, 1/5 goes to the son, 1/5 goes to the daughter, 1/6 to the butler, and 1/8 to a friend of his. How much does each one, or what do they get? So little Mikey raised his hand. She calls on him. He said, a lawyer. There you go. I like estate planning joke for the day. Okay, some other things here. We do have a survey on each of your tables. I see some of you filling it out, so we appreciate that. We like to get your information. Give us a rating, some feedback. Any concerns that you have, and then next steps, anything we can help you with. This helps us, plan for the future, and we love to get your feedback. So thanks for completing that. And then the last question is a key question to let us know how we did. And there is a new option. If you have your cell phone with you, you can take it out now. We're at that point. But there is a QR code on the top that you can scan to fill it out online as well. So. We have some more presentations. If you like this one, they only get better. We all know the food stays consistent. That's always good, and these are great. We got the next month, we're going to have our Q1 market insights with our adaptive team. And then in May, it'll be the team that I am on, the insurance team. We have some best practices on auto and home. So take a look at that and watch for the invitations. These good-looking guys are up next month, so they'll be presenting, as I said, on the market insights. A reminder that we are in tax season. We still have our $89 special. If you haven't, don't wait. The calendar's almost full, and April 7th is the last day to get your information to us if you want us to help with your taxes. And then lastly, a lot of you here know what we do. We're here to help you solve that financial puzzle. And if you are interested and haven't already, we do offer a free consultation. So get in touch with us on that. And the insurance team, we're always around because that changes all the time, but we're always there to help too. And the information's on the bottom how to contact us. And that's it. So I want to thank you all again for attending today. Hope you had a good time and got some good information. And feel free to stop by and talk to us after the show here. Thanks.